Welcome back to the deep dive. Today, we are going to take on a concept that most of us are taught from kindergarten is an absolute, unquestionable virtue. We are going to talk about peace.
And not just peace in the, abstract philosophical sense, but the very specific, very real machinery of peace in the legal world. We're talking about settlements, mediation, alternative dispute resolution.
Right. All the things that are supposed to keep us out of the courtroom and, save us from destroying each other financially and emotionally.
Because the prevailing narrative, the one we hear from, well, everywhere, from HR departments, from judges, from society in general, is that talking is always, always better than fighting.
Exactly. The moral high ground is found at the negotiating table. If someone offers you an olive branch, you take it. If someone says, let's mediate, you're supposed to say, yes, please. That's just the golden rule.
It absolutely is the golden rule, or at least it has been for the better part of 2 decades. It's the absolute prevailing wisdom in civil justice, and not just in the UK, where our main case is from today, but really globally.
The idea is that litigation is basically a failure of communication.
Right, precisely. And so courts have built this massive infrastructure to push, to prod, and sometimes to, let's be honest, threaten people into what's called alternative dispute resolution, or ADR.
The logic seems simple enough.
It is. Save money, save the court's time, and maybe even save the relationship between the people fighting.
But, and this is the hook for today's deep dive, it's a really counterintuitive one. What happens when that invitation to mediate isn't actually an olive branch? What happens when it's a trap?
And that's where we are today. We're seeing a new trend, or maybe it's just a clearer recognition of a very old trick, where the concept of peace is actually being weaponized. It's what people in the field are calling settlement leverage.
Settlement leverage. Okay, let's unpack that before we dive into the new case law. What does that actually look like in the real world? Because I think most of us, when we hear someone wants to settle, we think, oh, that's the reasonable thing to do.
It's a deeply cynical play. Imagine a claimant brings a lawsuit against you. They know, and maybe their lawyer knows, that the case is weak. It might even be total garbage.
Okay.
But they also know that for you, the defendant, just defending it, is going to cost an absolute fortune. We're talking tens, maybe hundreds of thousands of pounds in legal fees, not to mention your time, the stress, the distraction.
The sleepless nights.
All of it. So they send you a letter, an invitation to mediate. They say, come on, let's be reasonable. You know this will cost you $100 grand to fight. Just pay me 20 grand and we can all walk away.
And if you say no?
That's the trap. If you say no, they run to the judge and say, look how unreasonable the defendant is. They hate peace. They refuse to even talk. You should punish them for that.
It's basically legal blackmail wrapped in a yoga mat.
That's a fantastic way to put it.
Pay me something or I'll tell the judge you're mean. And for a long, long time, defendants were absolutely terrified to say no to that. They felt like they had to go sit in a room and negotiate with someone who was effectively trying to rob them just to check a box for the court.
Precisely. It creates this really perverse incentive structure where the process itself, the cost of fighting, becomes the punishment, regardless of who is actually right or wrong.
So why are we talking about this now? Has something changed?
Something big has changed. We're looking at a brand new case that just dropped. We're talking February 2026 that completely flips the script on this. It's a case called Grijns versus Grijns from the UK High Court.
Grijns v. Grijns, okay.
And if you are someone who deals with conflict, I mean, whether you're a lawyer, a business owner, or really just anyone interested in how power and leverage work, this case is like a breath of fresh air. It finally draws a line in the sand.
So it's the case that tells us when it is actually okay, and maybe even the smartest move, to look at an opponent and just say, no, I'm not talking to you.
Exactly. It's about the power of a well-placed and well-reasoned no.
So our mission today is to really unpack Grijns v. Grijns. We're going to get into the facts, which, by the way, are juicy. It's a family dispute, which is always messy.
Always.
And we're going to look at the legal doctrine. For our sources, we're pulling directly from the High Court judgment itself and also from the brand new 4th edition of the Jackson ADR Handbook, which is sort of the Bible on this stuff.
Right. And we'll also touch on some fascinating commentary on how this all fits into the global picture. We'll look at what's happening in places like California and even China.
And there's the timing issue. You mentioned it's February 2026.
Yes, which brings in this whole other cultural layer that we have to talk about.
It'll leave us hanging.
It's Peace Building and Conflict Prevention Month in the Rotary International world.
Ah, okay.
So you have this fascinating clash happening right now. On one side, you have this huge cultural push for peace, for dialogue, for soft skills. And on the other, you have the High Court of Justice saying, hang on, stop using the idea of peace as a weapon.
It really is the perfect storm. So let's dive in. Let's start with Section 1, the case study itself. Grijns v. Grijns. Give us the story. What actually happened here?
Okay, so the full citation is Grijns v. Grijns, 2026, EWHC 2853CH. It's playing out in the Chancery Division of the High Court.
Which usually handles what kind of cases?
Think complex stuff, big property disputes, trusts, business law, that sort of thing. But at its heart, this case is a classic, deeply messy family feud. You have family members fighting over assets, and that's already a recipe for, high emotion and really entrenched positions.
Family disputes are the absolute worst. It's never just about the money, is it? It's about who mom loved more in 1994 or who got the better birthday present.
That's it, exactly. The psychological stakes are almost always much, much higher than the financial ones. But what made this case really stand out to the judge wasn't just the family drama, it was the actual quality of the claim itself.
The legal argument.
Yes. The claimant, that's the person starting the lawsuit, was bringing a case that the court ultimately described as being, and this is a direct quote, outside the norm in terms of how weak it was.
Outside the norm. That's very polite judge speak for, what on earth are you doing in my courtroom? And here's what it is.
Essentially, yes. It's a sign of serious judicial skepticism. The claimant's whole case was relying on what the court called constructed assurances.
Constructed assurances. That sounds very technical. Can you break that down for us?
It's a polite way of saying they were making it up. Or, to be a bit more charitable, they were piecing together unrelated comments, maybe a half-remembered conversation from years ago, an offhand remark here and there, to build a narrative of a promise that never actually happened.
So they weren't lying about one big thing, but they were weaving together lots of little things into a story that was false.
That's a good way to put it. The judge did what judges do. They looked at the contemporaneous documents, the emails, the texts, the contracts that were written at the time, and they looked at how the parties actually behaved back then. And the conclusion was stark. The judge basically said, none of this matches the story you are telling me now.
Wow.
The story was inconsistent with the evidence. It was a fabrication, a narrative designed for one purpose, to support a lawsuit and try to get some money.
That's fascinating because it really touches on how memory works, doesn't it? Yeah. Sometimes people can convince themselves that their version of events is true. They can believe their own stories.
They absolutely can. But here the court is drawing a very clear line. It's saying, look, you might believe this now, but the hard evidence, the stuff that was written down at the time, shows that this reality you've constructed simply does not exist.
And in litigation, as you always say, evidence is king.
It is the beginning, the middle, and the end of the story. So you have a claimant with a constructed story suing their own family. And the court sees right through it. They didn't just lose, they lost spectacularly.
Or crashed and burned.
Completely. And this is where we get into what you could call the naughty step of legal costs. We really need to pause here and explain this because the difference between standard basis costs and indemnity basis costs is absolutely crucial to understanding the stakes in this case.
Okay, let's do it. What's the normal way costs are handled?
The default position in almost every case is the standard basis. So if you win, the loser pays your legal costs. But, and this is a huge but, the court acts like a very strict, very skeptical accountant. They go through your lawyer's bill line by line.
And they're looking for what?
Anything that seems a bit luxurious or disproportionate or not strictly necessary, they'll trim off costs that are vague. They'll say, did you really need 3 lawyers for that meeting? In practice, if you win on the standard basis, you'll probably only get back maybe 60 or 70% of what you actually paid your lawyers.
So even when you win, you still lose. You're still out of pocket by a huge amount of money. That's the so-called winner's curse in litigation.
That's exactly it. But then there is the indemnity basis. This is a different world. This is the court taking the gloves off. It completely flips the burden of proof. The court assumes all the costs you're claiming are reasonable unless the losing party can prove they were manifestly, wildly unreasonable.
So you get more of your money back?
Much more. You end up getting back something much closer to 90% or even 100% of your bill. It is a severe financial punishment. It's the court's way of saying, you should never, ever have brought this case. Your conduct was so out of line, so appalling, that the defendant shouldn't be out of pocket by a single penny because of your actions.
That is a massive swing. If your legal bill is, say, £100,000, that could be a $30,000 or £40,000 difference. That's the price of a new car.
Easily. So back to our case. In Grijns, the claimant gets absolutely hammered. They get hit with indemnity costs. The judge explicitly says the claim was sufficiently abusive to warrant that higher punitive level of costs.
So that sounds like the end of the story. Claimant brings a bogus case, loses, gets a massive bill, everyone goes home.
That's what you think. But that's not why we're talking about it today. There's a twist, a really audacious one.
Go on.
The twist, and this is the reason the case is making headlines in legal circles this week, is what the claimant tried to do after he lost. Even though he had brought a totally bogus claim, and even though he had lost comprehensively on every point, he turned around and argued that the defendants, the winners, should be penalized.
Wait. The loser wants the winner to be penalized. On what possible grounds?
On the grounds that they had a bad attitude toward mediation.
You're kidding me.
I am not. The claimant's lawyers argued that the defendants' costs award, the money they had won, should be slashed by 30 to 50%. Because, they argued, the defendants hadn't been enthusiastic enough about trying to settle the case before the trial.
The audacity is it's breathtaking. I dragged you into court on a complete fabrication. I made you spend a fortune defending yourself. I lost on every single point, but you were a bit rude because you didn't want to negotiate my fake claim, so you should have to pay.
That is precisely the argument they made in the high court. And here's the really scary part for anyone listening who has ever faced a lawsuit. In the past, that argument has sometimes worked.
Really? How is that possible?
Because there is a long, powerful line of case law that says refusing to mediate is, in and of itself, unreasonable conduct, even if you think you have a watertight case and you're going to win. The courts generally hate it when people refuse to talk.
So the claimant was trying to use that doctrine as a shield, even after his case was exposed as a sham.
He was trying to say, the rules of ADR apply to everyone, no matter how terrible my case is, you still have to play the game.
So, what did the High Court say in Grijns? Did this last-ditch, audacious strategy actually work?
It did not even a little bit. The court rejected the argument completely and forcefully. There was absolutely no cost penalty for the defendants. The judge looked at the reality of the situation on the ground.
What was that reality?
Well, first, the claim was fundamentally unfounded. We've covered that. Second, the claimant had wildly, totally unrealistic expectations. We're talking about a claimant who is demanding settlement offers in the region of £900,000.
$900,000 for a claim that the court eventually found was worth what?
Exactly zero.
That's not a negotiation gap. That's a different galaxy.
It's a chasm. And the judge effectively recognized that trying to negotiate with someone who is operating in a complete fantasy land isn't really mediation. It's just indulging a delusion. It's a waste of everyone's time and money.
But there was another layer to it, wasn't there? It wasn't just that the claim was bad.
No, and this is a really important nuance. The court pointed out that the defendants hadn't actually just given radio silence to the mediation idea. They hadn't just said no and slammed the door. They had actually tried to engage.
How so?
They'd made offers, they'd discussed the process, but the mediation stalled, and the reason it stalled was because the claimant started imposing unreasonable conditions on the process.
What kind of conditions?
Things like trying to exclude necessary parties from the discussion. In a complicated family property dispute, you usually need everyone with an interest in the property to be at the table. You can't settle a three-way dispute with only two of the people in the room.
So the claimant was trying to rig the mediation before it even started.
That's how the court saw it. They viewed it as the claimant creating artificial barriers, putting poison pills into the process. So the court said, look, the defendants tried. The reason this mediation failed wasn't because they were anti-peace. It was because you, the claimant, were making it impossible for it to succeed.
So the big takeaway from the facts of this specific case is, you can't bring a bogus claim, demand £1 million for it, try to rig the mediation rules, lose the trial badly, and then turn around and cry foul because the other side didn't want to play your ridiculous game.
Precisely. And it sounds so obvious, so much like common sense when you say it like that. But believe me, in the fog of war that is litigation, that line often gets incredibly blurred. Grijns just unblurs it. It sharpens the picture for everyone.
Okay, that makes perfect sense.
Yeah.
Let's move to Section 2 and talk more about that bigger picture, the legal doctrine. Because you mentioned earlier that there's a long line of case law that usually does punish people for refusing to mediate. I think we need to explain that context for our listeners to really get why Grijns is such a big deal.
We absolutely do. The 800-pound gorilla in the room of UK mediation law for the last 20 years is a case called Halsey v. Milton Keynes General NHS Trust.
Halsey. Got it.
This case is from 2004, so it's getting old now in legal terms, but it established what are known as the Halsey principles. And the big headline from Halsey was basically this: the court cannot force you to mediate against your will, because that would arguably breach your Article 6 human right to a fair trial, your right to have your day in court before a judge, so they can't compel it. But, and this is the part that changed everything, if you unreasonably refuse a serious invitation to mediate, the court can punish you in costs, even if you go on to win the trial.
That has always felt like a bit of a trap to me. We can't force you to go, but we will fine you heavily if you don't.
It's like a voluntary office donation that becomes mandatory if you want to keep your job.
It's a very, very strong nudge, let's put it that way. And for years, lawyers and their clients have been absolutely terrified of the Halsey risk. As soon as you get a letter suggesting mediation, a little panic button goes off in your head.
The fear is, if I say no and some judge down the line thinks I was being arrogant or stubborn, I could win my case and still lose all my costs.
Exactly. And this led to a real culture of what I'd call box-ticking mediation. People would show up, drink the bad coffee, sit in separate rooms for 4 hours with absolutely no intention of settling, just so they could go back to the court and say, see, we did it, we mediated, which is a complete waste of time and money for everyone involved. It actually degrades the whole concept of mediation.
It really does. It turns a tool for resolution into just another procedural hoop to jump through. So let's fast forward to February 2026. The commentary that's coming out now around Grijns, and we're looking at some notes here from the editors of the new Jackson ADR Handbook, is fascinating.
What are they saying?
They're not suggesting that Halsey is dead. They're not saying the rule is being softened. They're saying it is being sharpened.
Sharpened. Explain what that means.
It means that Grijns is acting as a clarifier. It reaffirms that the starting point, the default position, is still you really should mediate. You can't just ignore ADR. However, it carves out a much clearer, much more defined exception to that rule. You could call it a safe harbor.
I like the sound of a safe harbor. It sounds much better than the Halsey trap. So what are the coordinates? How do we get our boat into this safe harbor if we're facing a bogus lawsuit?
Well, based on the judgment in Grijns and the expert commentary that's followed, there seem to be 3 main conditions you need to meet to find shelter there.
Okay, condition 1.
Condition 1. The claim against you must be clearly unfounded or abusive. And this is a high bar. It can't just be, I think I'm right and they're wrong. Every single defendant in every single lawsuit thinks they're right. It has to be objectively, demonstrably clear that the claim is, for lack of a better word, garbage.
So a 50-50 case doesn't qualify. A case that's just weak might not even qualify. We're talking about something that is fundamentally provably flawed, abusive.
Correct. You need to be extremely confident on the merits. Okay, condition 2. The litigation has to appear to be designed purely to extract a settlement that's totally unrelated to the legal merits.
This goes back to the Grijns case with the £900,000 demand for a claim worth 0.
Exactly. If the other side is clearly using the cost of the legal process as their primary weapon rather than the strength of their actual legal argument, that is a huge red flag for the court, and it helps you get into the safe harbor.
Okay, and the third condition.
Condition 3 is all about your own behavior. The person refusing to mediate, the refuser, must have actually engaged sensibly with ADR in other ways. In Grijns, remember, the defendants didn't just put up a stone wall and ignore the claimant.
Right, they had made offers, they had tried to discuss the term.
They were active, they were responsive. You can't just be silent. You have to be able to show the court, look, we are reasonable people, but we are dealing with a completely unreasonable situation, and here is the proof.
This brings us to a really important concept that came up in our outline. It's called the buy-off principle. I think this is so powerful for any listener out there who feels like they are being bullied by a lawsuit.
I agree. This, for me, is the moral core of this entire decision. The experts are calling it the buy-off principle, and what it means is that the courts are now effectively saying this. Defendants do not have a legal or moral duty to buy off unfounded litigation just to avoid the risk of having to pay their own legal bills.
That is huge, because that is the entire business model of so many nuisance lawsuits. It's the model of patent trolls, of ambulance chasers, of anyone who files a lawsuit just to be a pain.
It is. Their model is based on a simple calculation. It will cost you £50,000 to defend this case and win, so just give me £10,000 and I'll go away. It's pure economic coercion.
And previously, the Halsey mediation rules kind of accidentally supported that model. Because if you refuse to even talk about that £10,000 demand, a judge might later say you were being unreasonable.
Precisely. Grijns puts a stop to that. It confirms, loud and clear, that your duty to consider ADR is not a blank check for blackmail. You are allowed to stand on your rights, to stand on the truth, and say, no, this claim is wrong, and I will not pay you a single penny to go away.
It's incredibly empowering, but it's also a bit dangerous, isn't it? Because you're making a big call. If you get it wrong, if you think the claim is abusive, but the judge ultimately disagrees with you, you're right back in that Halsey danger zone.
Absolutely. This is not a strategy for the faint of heart. This is high-stakes poker. If you misjudge how unfounded the claim against you really is, you could fall right back into the Halsey trap and get punished on costs. So you can't just go with your gut. You need a very clear strategy. You need to know how to refuse properly.
Which leads us perfectly into Section 3. Practical strategy. Let's get really tactical now. I'm a defendant. I've just received a letter from someone claiming I promised them my house based on a conversation we never had. They want to mediate next week. My immediate gut instinct is to delete the email, block their number, and pretend it never happened. Can I do that?
No. Hard no. Absolutely do not do that.
But why not? If the claim is obvious garbage, why do I have to give it the dignity of a response?
Because of another really important case called PGF2 SAVOMFS. This is the key precedent that deals specifically with silence. The court in that case held that silence in the face of a serious invitation to mediate is, in and of itself, presumptively unreasonable conduct.
So just ignoring them is seen as a hostile act.
It's seen as a red flag. It's viewed as discourteous, arrogant, and uncooperative. Even if the claim against you is completely insane, you must respond. Silence is the one thing you can't do.
Okay, so silence is death. I have to write a letter back. What does that letter say? Based on what we've learned from Grijns, how do I craft the perfect no thank you?
You have to master what we can call the art of the rejection letter. It's a delicate balance. You don't just write back and say, no, we won't mediate.
Or do you say?
You say, we are declining to mediate at this time because, and then you very clearly, very calmly list your reasons. And those reasons need to be specific, objective, and based on the evidence.
So step 1 is I need to document the merits, or lack thereof.
Yes. You have to explicitly state why you believe the claim is unfounded. You can say something like, your claim appears to rely on an alleged oral conversation on June 12th. However, we attach an email from you dated June 12th in which you state the exact opposite. Therefore, the factual basis of your claim appears to be non-existent.
So you're not just saying you're wrong. You're showing them the proof that they're wrong right there in the letter.
Exactly. You are creating the paper trail.
Right.
You need to show the judge, who might be reading this letter months or even years later, that you weren't just being stubborn or emotional. You had calmly looked at the case, you had realized it was hollow, and you had made a rational decision that mediation would be a complete waste of time and money for everyone.
It's all about building your case for the costs argument that you know is coming down the road.
Everything in litigation is about the paper trail. You need to keep a crystal clear record of all proposals, all your responses, and all your reasons. If you say, we won't mediate because you are demanding £900,000 on a claim that is objectively worthless, you need to write that down, send it. That letter is your shield. It's your insurance policy.
Now, what about this conditions trap? We touched on it a little when we talked about the facts of Grijns. The claimant lost the argument, partly because they put weird, unreasonable conditions on the mediation.
Right. This is the other side of the same coin. Let's say you are the one proposing mediation, or you're the one saying yes, but. You have to be incredibly careful. In Grijns, the claimant said, okay, I'll mediate, but we can't invite person X to the meeting.
But person X was crucial to the whole dispute.
They were central to it. So the court looked at that and said, that's not a genuine attempt to resolve this. That's an artificial barrier. It's a poison pill designed to make the mediation fail.
So if I were to say something like, sure, I'll mediate, but only if you admit you're wrong before we even start, that's not going to fly.
Not a chance. Or, I'll mediate, but only if we meet on the moon. Any condition you impose has to be reasonable and has to be aimed at actually helping the process succeed. If you propose conditions that make the mediation destined to fail from the outset, the court will see right through that and treat it as a refusal.
And from the defendant's perspective.
Conversely, if you are the defendant, and the claimant proposes unreasonable conditions, you are fully justified in rejecting them. You can write back and say, we cannot agree to mediate under those specific terms because they improperly exclude necessary parties. That is a valid, reasonable, and cost-safe reason to say no.
This is so practical. Let's do a quick teaching scenario. Imagine we're running a training exercise for some junior lawyers.
Okay, I like it.
You have a participant, they represent a big company. A former consultant sues them, claiming a massive bonus based on an oral contract that definitely doesn't exist. The consultant's lawyer sends a letter. Our client's claim is worth £500,000. Let's mediate next week. The junior lawyer has to draft the response. What does a fail look like, and what does a pass look like?
Okay, a fail is easy. A fail looks like this. Dear claimant's lawyer, your case is stupid and you know it. We will see you in court. Go away.
Short, sweet, and incredibly dangerous.
Very dangerous. It just shows attitude. It doesn't explain why the case is weak. It doesn't engage with the substance. It just invites a judge to think your client is arrogant and uncooperative.
Okay, so what does a pass look like? What's the Grijns level A+ response?
A pass would be something like this. Dear claimant's lawyer, we have received and reviewed your request to mediate. We note that your client's claim relies entirely on an alleged oral contract. This alleged contract directly contradicts the written service agreement signed by both our clients, specifically Clause 14.7, which is an entire agreement clause. Given that the claim appears to be legally unfounded and is contradicted by the signed documentary evidence, we do not believe that a mediation is likely to be a productive use of time or costs at this early stage.
That's very good. It's firm but polite.
But you add one more sentence. However, should you be able to provide any contemporaneous written evidence in support of your client's claim, we would of course be willing to reconsider our position.
Oh, that's just brilliant. We were made open to considering fresh evidence. It makes you look incredibly reasonable, but you're still saying a very firm no to the immediate demand.
It keeps the door just slightly ajar, which judges absolutely love. It signals, I'm a reasonable person. If you can prove to me that you aren't just making this up, I'm willing to talk. But it firmly refuses the immediate pressure to spend £20,000 on a mediation for a bogus claim. It is cost-safe, but it is also incredibly firm.
It's the velvet glove over the iron fist. I love it. Okay, let's zoom out. This has been very focused on the UK High Court, which is great, but our listeners are global. So let's move to Section 4. Is this just a UK thing? Is the rest of the world also moving away from compulsory mediation, or is Grijns an outlier swimming against the tide?
That is the big critical question. And if we look at the global context, Grijns is, in some ways, actually swimming against the prevailing stream. The broader trajectory globally is towards more mandatory ADR, not less.
Okay, give us some examples. Where are we seeing this big push for more mediation?
Well, a great example is California. They have legislation, Assembly Bill 1523, AB 1523. This has been pushing for higher and higher case value thresholds for mandatory mediation. The trend in the U.S., especially in progressive, often backlogged jurisdictions like California, is to bake mediation into the civil justice process earlier and for bigger and bigger cases.
And what's the goal there?
It's pretty straightforward. They want to clear the dockets, the courts are overwhelmed, so they want to force people to sit down and talk before they're allowed to take up a judge's precious time.
And what about further east? You mentioned China.
China is a massive, fascinating example. For years now, they've been rolling out what they call the Eastern Experience pilot schemes, and this is a really deep integration of mediation directly into the court system itself. In many of these pilot courts in China, you almost have to go through a formal mediation phase, often with a court-appointed mediator, before you can ever get a judgment from a judge.
So it's not really alternative dispute resolution anymore?
Exactly. It's becoming the primary dispute resolution method, with a trial as the alternative. It's becoming completely embedded in their civil justice system.
So if the rest of the world is shouting, mediate, 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 isn't a decision like Grijns a bit dangerous? Isn't it telling UK lawyers to do the exact opposite of what the global trend seems to be?
I don't think so. I see it less as a contradiction and more as a synthesis. Grijns isn't a contradiction of the pro-ADR trend. It's a vital fine-tuning of it.
How do you mean?
Look, even in a system that absolutely loves and mandates mediation, you have to have a safety valve. You must have a way to deal with abuse of the process. If you make mediation 100% mandatory with zero exceptions for any reason, you inadvertently empower the scammers. You empower the blackmailers we talked about earlier.
Because if I know that you have to mediate with me no matter what, I can sue you for anything, knowing that you'll be forced to spend time and money sitting in a room with me.
Exactly. The process itself becomes the punishment. So courts, even the most pro-ADR courts in the world, like those in China or California, ultimately need to have mechanisms to stop people from abusing that mandate. They have to stop people from hiding behind the "we won't mediate" excuse in normal, legitimate cases. But they also must have a way to protect defendants from these weaponized, baseless claims.
So Grijns is that balance point.
I think Grijns is precisely that balance point. It's the UK's version of that safety valve. It's the court saying, we love mediation, we want you to do it, but we hate the abuse of our process even more.
It's like antibiotics. Antibiotics are great. We want everyone to have access to them to cure real infections. But if you start using them for every little sniffle, or when you don't need them at all, you create superbugs and you ruin the effectiveness of the drug for everyone.
That is a surprisingly excellent analogy. Yes.
Grijns is preventing the legal superbugs.
It is. Overusing the remedy, or using it in bad faith, weakens the entire system.
I try my best. Okay, let's move to the final layer of our deep dive today. This is section 5, the cultural layer. We've done the hard law, we've done the practical strategy. Now let's talk about the culture. Because laws don't exist in a vacuum, do they? They exist within society. And right now, as we record this in February 2026, there is a very specific cultural backdrop to this conversation.
Yes. As we mentioned at the top, February is Peace Building and Conflict Prevention Resolution Month for Rotary International.
And for anyone who doesn't know, Rotary is a huge global network of service clubs. We're talking 1.4 million members around the world. And they've decided to dedicate the entire month of February to the idea of peace.
And this is where we get into this really interesting distinction between what we call soft law and hard law.
Okay, define those for us.
Grijns v. Grijns is hard law. It is judges, rules, cost orders, penalties. It is the formal machinery of the state enforcing its will. Rotary, on the other hand, represents soft law. It is norms, culture, expectations, and peer pressure.
It's the vibe.
It is the vibe. But the vibe really, really matters in legal practice and in business. Right now, all over the world, Rotary clubs are running programming on conflict prevention. They're doing workshops, they're hosting expert speakers, they're funding peace-building scholarships. This creates what sociologists call a normative environment.
What does that mean?
It normalizes the idea that we should talk things out. It makes it the default cultural expectation that conflict should be resolved constructively, not escalated into a war.
So on the one hand, you have this big cultural wave saying make peace, not war. And on the other, you have this new legal decision saying, actually, you can refuse peace talks. How do those two things possibly intersect?
I think they intersect perfectly in the definition of good faith. Rotary's global push for peace isn't about surrendering to bullies. It's not about appeasement. It's about constructive good faith engagement.
It's about preventing conflict in the first place.
Exactly. Their grassroots initiatives, literacy programs, youth leadership camps, clean water projects, these are all about preventing the causes of conflict long term. And Grijns is about handling the abuse of the conflict resolution mechanisms we've built. They're two sides of the same coin.
So a smart lawyer or a mediator can actually use this cultural moment to their advantage.
Absolutely. If I'm a mediator or a litigation trainer, I'm using February to talk to my clients about this very thing. I'm saying, look, it's peace building month. The entire world is telling us we should be trying to resolve our disputes, but true peace requires honesty. It requires a valid, good faith basis for a discussion.
So you can connect the very technical legal doctrine of Grijns to this broader, much more accessible narrative of peace building.
That's it. You can tell a client, we are pro-peace. That's why we are always willing to mediate legitimate disputes, but we are also pro-justice. And justice means not being forced to entertain a shakedown.
That's a powerful message because clients understand peace building or doing the right thing. They might not understand the nuances of indemnity costs on an interim application.
Exactly. If you can bridge that gap, if you can explain that refusing a bogus mediation is actually an act of integrity, an act that protects the peace process, then you are winning. You are aligning your legal strategy with the cultural moment in a very powerful way.
That is a really sophisticated way to look at it. So it's not just my lawyer says no. It's we are protecting the integrity of the entire peace process by refusing to let it be misused by people acting in bad faith.
That is the argument. Think about it. If you allow the process to be weaponized, you degrade the value of mediation for everyone else. If mediation gets a reputation as the thing you do to extract nuisance money from innocent people, then good people won't want to mediate their legitimate disputes anymore.
So in a strange way, Grijns is actually the great defender of mediation by policing its borders.
That is exactly how I see it. It cleans up the neighborhood so that the rest of us can live there in peace.
Wow. We have covered a huge amount of ground today. We started with a messy family fighting over property in the UK High Court. We looked at the mechanics of indemnity costs. We learned how to write the perfect rejection letter. We took a quick world tour to California and China, and we ended up with the philosophy of global peace.
Let's try to summarize this for the listener who is maybe prepping for a difficult meeting or just trying to retain the golden nuggets from this deep dive.
Okay, let's do it. I think the big aha moment is this. Being pro-peace does not mean you have to be a doormat. The Grijns case teaches us that you can refuse mediation, but you have to earn the right to do so.
And the number one rule is you can't just be silent.
No silence, ever. You must respond, you must show your work, you have to document precisely why the claim against you is baseless, point to the inconsistencies, the lack of evidence, the constructed assurances, and you must explicitly link that weakness, in their case, directly to your refusal to mediate. We will not mediate because your claim is unfounded.
And always remember that buy-off principle. You do not have to pay a toll to a legal troll. Correct. The courts will now protect you from costs sanctions if you are refusing a truly abusive claim. But, and this is a big caveat, be very, very careful. Make sure you are right about the merits of your case before you take that stand.
And finally, connect the hard law with the soft law.
Yes. Use the cultural context. Use Rotary's Peacebuilding Month. Frame your strategy not as an act of aggression, but as an act of maintaining the integrity of dispute resolution itself. True peace, real peace, requires good faith from both sides. And if one side is clearly acting in bad faith, refusing to engage is not just reasonable, it's the right thing to do.
Which brings us to our final thought. We always like to leave you with something to chew on, something a little provocative to think about after the show ends.
We do. And I think, we focus so much today on whether the defendant's refusal is reasonable. We keep asking, is the defendant allowed to say no? But I think Grijns raises a much darker and maybe more interesting question about the person sending the invitation. If mediation is supposed to be this incredible tool for peace, at what point does using it as a threat, mediate with me, pay me something, or I'll ruin you with legal costs? At what point does that invitation actually become an act of aggression? We usually think of the refusal as the hostile act. But maybe, in cases like this, the invitation itself is the first shot fired.
When does the olive branch become a bludgeon?
Exactly. When does the symbol of peace become a weapon of war? I think Grijns v. Grijns suggests that the courts are finally starting to see the weapon in the hand of the so-called peacemaker. And that, I think, changes everything.
That is a fantastic and slightly chilling place to leave it. A little bit of legal philosophy to go with your morning coffee. Thank you so much for listening to The Deep Dive. We hope this helps you navigate your next dispute, or at the very least, helps you sound really smart at a dinner party.
Keep looking at the details. The truth, as they say, is always in the details.
Keep learning and stay curious. We'll catch you on the next one.